And it's relating to a complaint filed by Peggy Adler, who was the complainant against Lisa MacDonald and Cynthia Watts. The Board of Ethics previously found probable cause, and we issued a written finding of probable cause that's dated February 1, 2012. What the board's going to do, we have conducted a confidential investigation. That investigation is now public because of the finding of probable cause, and we have marked our record of evidence, and we're going to simply introduce that record of evidence at this public hearing. I'm going to just read through the 20 items that are part of our record. Number one is the complaint that had been filed by the complainant. Number two were letters to the respondents from the board dated December 16th, 2011. Number three is the response from Cynthia Watts that was dated December 27th, 2011. Number four, the written response from Lisa MacDonald dated January 3rd, 2012. Number five, all agenda and minutes filed with the town clerk's office dated December 13th, January 10th, January 19th, January 26th, and January 31st. Number six was another letter to Cynthia Watts from the Board of Ethics. And number seven is a letter to Lisa MacDonald from the Board of Ethics. Number eight was a letter to John Main from the Board of Ethics. 9 is a copy of an email from our clerk to an attorney representing Lisa MacDonald. 10 is a copy of an email from that attorney, Herbert Shepherdson, dated January 13th, confirming their attendance at our meeting. Number 11, a letter from Cynthia Watts to myself as chairman, dated January 31, 2012. Number 12, planning and zoning application for number SP King 09123 and SP 11-242. Number 13 was the Planning and Zoning Commission's bylaws. 14 was a handwritten letter and proposed stipulation and agreement from John Watts to Planning and Zoning. 15 is a letter to Planning and Zoning from attorney David M. Royston dated July 6, 2011. Number 16 is a letter submitted by Planning and Zoning Chairman John Main to the Board of Ethics, and that came from attorney David Royston dated September 12, 2011. Number 17 is a letter to Planning and Zoning from attorney David M. Royston dated December 9, 2011. And then we had recorded sworn testimony from the respondents, Lisa MacDonald, her husband Michael MacDonald, and the respondent Cynthia Watts, and John Main, chairman of the Planning and Zoning Commission. Number 19 is our written finding of probable cause that was voted on and issued by the Board of Ethics. That's dated February 1. And finally, the legal notice of public hearing for today, March 1, 2012. The board has received correspondence from attorneys for the respondents. One dated February 28, 2012, addressed to our clerk from attorney Herbert Shepherdson. I was copied and town council was copied. And a letter received or sent February 29th, 2012 on behalf of Cynthia Watts from attorney Justin Clark. They include memorandum of law and exhibits attached. I think as far as the board is concerned, these are considered legal argument and will be considered by the board and marked as part of the record. It's our understanding that the respondents do not intend to appear today. They are right to appear at this hearing and present any further evidence. And I think that's true. I don't see the respondents here, Lisa MacDonald or Cynthia Watts or anyone on their behalf present. And it's, what do we say, 6 after 7 o'clock right now? Right. Then I would suggest that we could close the record of this hearing. We have the record from our investigation. What's the board think?
I make a motion
Close the evidence. All right, we will, I'll entertain a motion to close the evidence of this public hearing.
Is there any other possible evidence that could come?
Anyone here to present evidence with respect to the written finding of probable cause? So you want to identify yourself, please?
Mr. Chairman, I am consultant of the F-33 Kelsey Town Road, Clinton obviously, and I'm also a member of the Planning and Zoning Commission, and I was part and parcel of the decision that was made on, I believe it was November 14th. And I just wanted to add some flavor to what transpired that evening. I feel somewhat burdened because I was the one that initially challenged the ability of one member of the Planning and Zoning Board to sit.
Excuse me, can you use the microphone, please? I can't hear this.
And not recuse. I don't know if there is a microphone. I'll try to speak loud.
Okay, thank you.
It's come to my attention that there's been some legal argument made, and I wanted to be clear about the argument I made that evening. The argument I made was based upon a seminar, a paper, memorandum of law, if we want to call it that I had attended, the seminar that I had attended at the University of Connecticut. And I specifically cited a case from that memorandum of law, that seminar paper that was prepared by the firm of Cohen and Wolf. I had challenged the ability of, specifically the respondent Cynthia Watts to sit at earlier meetings. And at one point, there was some discussion that flowed from our counsel, Mr. Royston, whose letters I think are in the record. And I won't speak for him because although I haven't seen those letters, I surmise he may have given some background information as well. My point was simply that, based upon our bylaws and the law as I understood it in the state of Connecticut, and specifically Section 811 and 821, it was dangerous for the commission to have seated an individual who, in my opinion, as a member, had a conflict of interest for personal reasons. My challenge was not based upon pecuniary interests. I had no reason to believe any of that pertained to that issue. I felt that the personal reason was first and foremost, given that the respondent, Ms. Watts, is the sister of the applicant and reapplicant, Mr. John Watts. And I actually cited a case, and if the commission would bear with me, I would like to hand in as additional evidence, I guess, if that's how you want to take it, of the paper I referred to. And specifically in doing so, I want to cite page 205, from which the case Stanley versus New London Planning and Zoning Commission came from, that I cited. That's on page 205. Unfortunately, I have only one copy. That is actually my copy, but I have a separate one, so you may keep that. What I was alluding to was the issue of conflict of interest, but that paper very much goes into another issue, and that's predisposition. And I only mention that because they're two separate and distinct matters when it comes to planning and zoning, or really any board's decisions, but certainly on land use boards, they're very relevant issues, both predisposition and conflict of interest. And I tried to get into some detail about that. I wasn't able to my satisfaction, but ultimately when the chairman posed the question, is there anybody here that challenges the ability of any member to sit, I raised the issue as I had on prior occasions. The rest is history. We took a vote. The vote was 5-2. But as an individual member of a board, I feel a duty, an obligation to speak out because it does cast upon the full board. Regardless of what the vote is, the fact that there is this issue before you casts a negative light, I feel, on the decision. And I just want to point out that my understanding of Section 811 of the Connecticut General Statutes and 821 of the Connecticut General Statutes call for, once there is a recusal, as I believe there should have been at least for one of these respondents, it calls for the replacement of that individual with an alternate. That wasn't done, but in fairness, I don't ever recall it being done by this Planning and Zoning Commission. Our bylaws are silent as to that procedure, but I think the statute is clear. The reason I'm here tonight is I read, as part of the record, the letter that Cynthia Watts submitted where she speaks about your ethical rules being applicable. And I think it's an awfully narrow way to look at the problem. I think the statutes are applicable, our bylaws are applicable, and our bylaws clearly track the statute with respect to pecuniary and personal interest. I don't have any other points to make. I just wanted to call your attention to the paper that I utilized to issue the challenge.
Okay, I'm going to accept what you say as argument in this case, but I do have a question for you, and I think if you're going to present evidence, then I want to swear you in. Okay?
You're going to ask me a question?
I'm going to ask you a question. Raise your right hand. Do you solemnly swear or affirm, as the case may be, that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
All right, thank you. Was the code of ethics ever discussed by the Planning and Zoning Commission?
No.
And you never heard Attorney Royston talking about the code of ethics as opposed to the statutes that you've referred to?
I don't recall that at all, no.
Can I ask? Sure. If I could ask two questions. How many years have you been on planning and zoning?
A little over 2 years.
2 years. Okay. And during that time that you served on the board, did you ever witness anyone recusing themselves for
Yes.
any reason whatsoever?
Yes.
You have.
I'll follow up with that. Have you taken a look at the Planning and Zoning Commission bylaws? We have marked them as an exhibit here, and it does seem to suggest that your own bylaws call for the appointment of an alternate if someone recuses themselves.
I have looked at the bylaws. I'm not sure I come to that conclusion, but I know they track the statute, and the statute provides for the appointment of an alternate.
Okay. Okay, but you've never seen that happen?
You're asking me to go back over
Fair enough.
something that occurred. You asked me about the recusal. There was a recusal. In fact, there was a recusal of these same two individuals at the initial application stage. I believe that was either in November of 2009 or December of 2010. I can't be absolutely certain.
Okay.
And at that time, I don't recall whether there were other members seated in their stead. But I have to say that if we have a quorum, it probably wasn't. I mean, the record would bear that out if it's still available. I just don't recall.
Anybody else? Thank you.
Thank you very much.
Thank you.
Thank you.
Anybody else?
Yeah,
Well, I got a hand in the back
sure,
first.
that's fine, I'm fine.
Vincent Semino, 161 East Main Street, Clinton.
Right, is this gonna be argument, or do you have
No, I'd like to present additional evidence.
evidence?
I'd like to present additional evidence that I believe.
Let me first
Oh, I'm sorry,
stop you.
sure.
Give me
please.
an idea, an offer of what it is that you, the subject matter that you want to.
Yes. I'd like to offer evidence to the commission that Attorney Cynthia Watts perjured herself in her testimony to the Ethics Commission.
All right, I'm not gonna allow that because I don't find that to be relevant to this issue of the findings that we have made of probable cause. So we've listed, I'm sure you've read this.
Yes.
Do you have anything to offer that would contradict any of the findings of fact that we made?
Contradict, no. In fact, I think it's additional support for the findings that you made.
Okay, but I don't want to get into, it's our job to decide credibility, and we did examine the witnesses, and their testimony is part of the record, but I don't want to go beyond that.
I understand this has to do with the direct testimony that was given by Cynthia Watts to the commission. And
Can you identify what it is relevant to in terms of the numbers of
I don't have the document in front of me.
specific findings to it?
I can tell you that it has to do with, I believe Cynthia Watts was asked directly if she had ever represented her brother. And in fact, she represented her brother with regard to this exact situation. And I'd like to offer is the minutes from the Selectmen's special meeting on February 8th, 2006. And there's an item, sale of town property. And the very first line in the minutes reads, Attorney Cynthia Watts representing her brother, Attorney John Watts.
Okay, thank you, but I'm gonna not allow that because it's not relevant to this specific complaint that relates to the two applications that were made in 2009 and then the resubmission in 2011.
Okay.
All right, thank you. Anybody else have evidence, that, again, that's related to the findings of probable cause? Sam?
I'm a member of the Planning and Zoning Commission, and I think I have evidence that I'd like to reiterate here. I've made a statement, a prepared statement.
Okay, is this, first could you state your
Specifically,
name?
Pamela Fritz.
Thank you. And does this relate to any of the findings with respect to these applications?
Yes.
All right.
It also, Attorney Delia's statements, it embellishes, because I was on the planning board before he was on the planning board.
Okay, then I'm gonna swear you in, okay?
Okay.
Raise your right hand. Do you swear or affirm, as the case may be, that the testimony that you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God, upon penalty of perjury?
I do.
Thank you.
Okay. And I will give you a copy of this statement also, please. And I'd like to read it into the record. I have been a member of the Planning and Zoning Commission since 2007. I was originally appointed to fill a vacated position and was subsequently elected in 2007, again in 2011 to serve on this commission. I probably should have started saying that my name is Pamela Fritz and I live at 1416 Old Road in Clinton. On November 14th, 2011, I was present at the Planning and Zoning Commission meeting. At that meeting, the site plan for the 186 Main Street, also referred to as the site plan application by John Watts, was again before the commission for a vote. Although my remarks at that meeting are on the tape, which is public record, I feel it is pertinent this time that I reiterate a portion of my remarks, or actually my remarks for this public hearing. Because at that time, I specifically quoted the following from the Connecticut State Statutes, the Office of Policy and Management, and this same documentation, which is in our bylaws of the Planning and Zoning Commission. It states that no member of any zoning commission or board or zoning board of appeals shall participate in the hearing or decision of the board/commission which he is a member, upon any matter in which he is directly or indirectly interested in a personal or financial sense. At that time, I personally asked both Cynthia Watts and Lisa MacDonald to recuse themselves due to their personal and financial connections to the present site plan before the commission. I reiterated that this site plan before us was the same original site plan submitted to Planning and Zoning Commission, and that's back in about 2007. It was earlier than that. On the record, both Cynthia Watts, at that time, on the record, both Cynthia Watts and Lisa MacDonald did recuse themselves for this very same, and I might reiterate, the very same site plan that came before us in 2007. I also would like to refer to a letter that was sent on September 12th from our attorney Royston to the Planning and Zoning Chair, John Main, where he cites Thorne versus the Old Saybrook Zoning Commission, 1979. This case stands for two basic propositions relevant here. First, the relationship of the brother and sister constitutes, quote, an interest in a personal sense, end quote. And second, the participation of a disqualified person can render the action of a commission a nullity. And that is my concern as a servant of the Planning and Zoning Commission, that this, let me finish reading this. I am concerned that the way the Planning and Zoning Commissioners have conducted themselves in this matter is setting a dangerous precedent for those who serve on all of our town boards and commissions. If our commissions cannot abide by state statute, our own bylaws, and the rules of our Ethics Commission, we are headed down a slippery slope. If we are allowed disqualified persons to participate in a commission decision, we run the risk of being challenged on these decisions and even having them nullified. And a precedent, I believe, must be set to avoid this from happening in the future. I also want you to know that on other occasions at Planning and Zoning, since 2007, when these parties would not recuse themselves, I discussed this, I tried to bring this forward because I, again, was citing our own statutes, state statute, which is written into our bylaws as well. But it was ignored, and I just want to put that on the record that I was adamant about that because I felt it was so important. Do you have any questions for me? Thank you.
Thank you.
Peggy Adler, 5 Liberty Street. You had asked at Tom Dalia about the whether people on the board of who's on the Planning and Zoning Commission had been apprised of the ethics ordinance. I had inquired in the first selectman's office of Mary Scatino.
Is this going to be?
It's just that they knew about it and they both signed off on having received it. That's all I wanted for the record. You asked
The code of ethics?
the code of ethics, yes. Okay. They each received it and they signed off on having received it.
I don't think that that's relevant
Well,
to what
you
we're
would,
deciding.
since you had asked Attorney Dalia about it,
I asked about what had happened at a particular Planning and Zoning Commission and whether the code of ethics was discussed. He answered that.
oh, I thought you were asking if they had been apprised of it. I'm
No.
sorry, I
No,
apologize.
okay.
I'm sorry to, yeah, but it just reminded me of something that you did ask Attorney Dalia that I would like to comment upon because I do know the answer. Yes, I have been at many meetings where, in previous years, nothing to do with this hearing, where people who were involved directly recused themselves. And alternates were seated at those particular meetings. Now, in my mind, I can kind of remember them, but I'd have to go back and look at the record. But
Okay.
since I've served on the board in 2007, yes, that has happened.
Does anyone else wish to present evidence? All right, then we had a motion.
I'll make,
Do we have a motion?
okay, I'll make a motion to close the record.
Close the record with regard to evidence.
I'll second that.
Second, all in favor? Aye. Okay. All right. We can decide this now, when you think about it. We've all taken a look at the legal argument that the attorneys have made. I think the facts are undisputed, and I think that we set them out very plainly in our finding of probable cause. The arguments being made, as I understand them by the attorneys, are that the complaint should be dismissed because we, let's see, we cite a provision of the code that was not cited by the complainant, specifically section 4, subsection E. I don't find that argument persuasive. I don't think it's up to the complainant to decide which particular provisions of the code are applicable. The complainant brought forth facts as she knew them, and then it was our job to investigate the facts and determine what the facts are, and then apply the facts to the law. So I don't find that argument persuasive that we somehow went outside the complaint. I do not believe that the word transaction is limited to a financial transaction between the town and another person. A transaction is, in plain language, is an event. It can be a meeting, it can be a vote by a board. It does not, I think that's the intent, plain language use of that word. So the argument that neither of the respondents received any direct personal financial gain from a transaction, I don't find that to be persuasive. With respect to Ms. MacDonald, I understand the argument that her husband had been paid in full prior to the resubmission of the application, but I find that that's where subsection E comes into play, because she has a personal interest in an application and plans created by her husband. And I'd also say that this was a two-phase project, and although her husband did not indicate to us that there was no contract or proposal for him to work on phase 2, he didn't deny that it was possible that he could work on phase 2. And when we asked him to give us copies of his contract with Mr. Watts, he never followed up and gave us copies of those contracts. With respect to the fact that Attorney Royston gave opinions, we now have some testimony that the code of ethics was not discussed. It was the state statutes that were discussed. And Attorney Royston seemed to directly, he specifically wrote about Attorney Cynthia Watts and the potential conflict. I mean, that's in our record. And there's no correspondence, affidavit, testimony from Attorney Royston indicating that he even reviewed the code of ethics, the town code of ethics, or gave any opinion with respect to that. So I don't find the arguments for dismissal persuasive myself. Anyone else want to?
No, I'm not prepared to vote tonight on this. We did get a lot of information just even this afternoon. I do want to give that information. How long do we have?
Well, we can continue this to another day. I'm not sure that there is
Our vote has to be at a public hearing?
Yes, it does. vote has to be, and our deliberations need to be at a public hearing. I think after we vote, there's a time limit.
That we have 14 days to deliberate.
Is that right? 15 calendar days after conclusion of the hearing. Now, we could continue the hearing for deliberations, but why don't we, if we can stick to that 15-day.
Oh, absolutely, I just need a couple days to form some thoughts.
Okay. Anyone else?
Well, Mr. Chairman, I am disappointed that Ms. Watts and Ms. MacDonald are not here this evening. I find that very sad. I see no evidence in the letters that their attorneys have written and presented to us that would weaken the probable cause that we have already approved and set forward. So, as far as I'm concerned, and I appreciate those people who spoke this evening, I'm prepared to vote tonight. I know that we received this material late, but I just have seen no other evidence that would abrogate what we have discussed and decided on. I don't know what more there could be. I think we can spend more time on any further recommendations. I know that's within our purview as the Board of Ethics. I also want to say that I've served on the Board of Ethics before. This is really the first time that a very serious case has come to the board since I have been a member. And I want to say that as far as I'm concerned, this board has followed the process very carefully and very respectfully, and I really appreciate your leadership in this, especially Ken. I know that I couldn't have done this, but I really do appreciate it, and I respect the members who are on this board. We have approved this finding by probable cause unanimously, and I feel very disappointed as well in the attorneys and their language in these letters, which I find to be inflammatory and not very helpful, either for their clients or for this process. I want to say that right up front. I want the town of Clinton to know that we have a Board of Ethics that is working, and is working for the people of this community. And we have taken our work here very seriously. And I can see by your presence tonight that you take our work seriously too.
Thank you.
Well, no, I'm good. I could vote tonight, but I would, I'd like to give John
I could
his
vote tonight,
his time
too.
if he needs it.
Not ready. Not tonight.
Okay, we will respect your wishes.
Thank you.
Since the defendants are not here this evening, we have their statements read and for the public record, for the public to hear their statements, so we can at least understand what their response was. I don't need to see a copy of both of them.
Well, they're, you mean the attorneys?
Whatever, they're not here, they have their legal counsel respond, and I'd like to hear that read into the public record aloud for the people in the audience. If that would be okay?
Yeah, if they're available, we can make copies, I'm sure. Anybody that's interested
It might jog somebody's memory, it might help to bring new evidence forward, but of course you close that, but it would be interesting to have that read in the public
I
record.
fully agree. I think it would be very important to have them read.
I'm curious.
Well, they could have come to this hearing and read them themselves, or their attorneys could have. So I'm just not gonna do that, but it is part of the public record, and we've closed the record for evidence, so.
This isn't new evidence, this is existing evidence.
Pardon me?
This is existing evidence, not new evidence. I know you closed the record, I just asked that we might hear that response from the applicant, since they aren't here, and it would be nice to hear it.
We can certainly, like I said, we're gonna make copies, but I think what we're gonna do now is have a motion to continue this hearing to another date, and I don't know whether can we set that date right now?
Do we need to continue it here, or just have
Yeah, I
a
think
regular meeting?
I think we have to continue this. It's a public, we're not gonna hear any more evidence.
Right.
This is just for our deliberations. Okay.
Okay, yes.
Okay. I mean, I think that's what we should call it, because it's a public hearing, it was noticed for tonight.
It was, certainly the purpose of the hearing was outlined, but I just figured the hearing would be over, we'd have a chance to deliberate, discuss, and vote.
And we do, so that's what we're gonna continue.
Okay.
Okay?
If that's the way it is.
Okay. All right. Do we have a date that we can do that right now?
Tuesday or a Thursday evening?
Okay. How much time do you want now?
Just a couple days, no, soon.
That works for me. Yeah. Do you want to make a motion then to continue it?
Make a motion to continue the hearing till Tuesday,
Tuesday, March 6th.
March 6th.
7 o'clock.
7 o'clock here in the green room?
I
Town
don't know,
hall.
that's kind of up to the clerk, but it'll certainly be at town hall,
Right,
right?
correct.
Okay.
Will be-
Second?
Second.
There will be a public notice of the new meeting,
Yes.
There has to be.
Yep.
newspaper, yeah,
Not newspapers, I
not
don't.
newspapers.
It will be posted, yeah.
It'll be posted.
Yeah.
Wednesday, Thursday.
And we're announcing it right here, so it's gonna be Tuesday,
Yeah.
March 6th, 7 PM, Town Hall.
We'll have to find an internet news service to put it
It'll be on our website.
And do we have a second on that? Second, and any discussion? All in favor? Aye. All right, thank you. Thank you, everyone.